Hi, my name is Norshifa Nasifa binti Harisham and my student ID is 03633304. So I will be advising on both State Aramika and State Butuna according to the international law for their bilateral treaty. Definitions of treaty under Article 2 Sub 1A Vienna Convention on the Law of Treaties 1969 from a general article of FIFA Atia perspective, where a treaty is generally defined as a legally binding written agreement between two states that is subject to the international law. So whether embodied in a single instrument or in a two or more related instruments and whatever its particular designation. There are two types of treaty, which is bilaterals and unilateral. Moving on to the introduction, according to this understanding, treaties like the bilateral agreement between State Aramika and State Butuna over the Joint Dam project are legally binding. So according to the Article 92 of the UN Charter, the ICJ is the primary court of the UN and is responsible for interpreting and enforcing international law. So the ICJ stated Article 38 sub 1 also lists the main sources of international law that influence the court ruling. So these sources can help identify the just Congress norm and customary legal obligation as well as how treaty law should be interpreted and applied. Next is Article 93 of UN Charter. So all UN members are automatically parties to the ICJ statute. A fundamental principle of a treaty law is pata susavanda under Article 26 of VCLT, which is a require a government to uphold their treaty obligation in a good faith. So a treaty may be suspended or cancelled, which is in a certain extraordinary condition, such as a material breach, a fundamental change or circumstances, which is known as rebus instantiatus, or a contradiction with the just Congress standard. Moving on to the issue 1, analyze the legality of State Aramika's suspension under VCLT. So State Aramika has unilaterally suspended a bilateral agreement with State Botuna on a cooperative dam project, which is claiming that Botuna has a substantial violated the agreements by disagreeing agreed upon environmental protection. So, under the VCLT, a fundamental document that regulates the creations, interpretations, and terminations or suspension of international treaties where the legality of this suspension must be evaluated. So, Article 26 Pata Sursabanda, so every treaty in force is binding upon the parties to it and must be performed by them in a good faith. So, Article 60, where termination or suspension of a treaty as a consequences of a breach. So, from a journal articles Maria Sorvri perspective, where however, even though the VCLT is a primary tool that govern the treaty law, but Article 60 of VCLT only regulates one specific aspect of treaty violation, which is namely the impact of a material breach of the legal force or operation of that treaty through the termination or suspension of operation, as well as Article 60 sub 1 and Article 60 sub 3. So next is a material breach claim under Article 60 in order to support its suspension under Article 60. So State Aramika must prove three, which is the environmental safeguard violated by Botuna that are essentials to the treaty's object and purpose. Second is the breach is material. Is it substantial? Undermines the performance of efficacy of the treaty. And third is Aramika has acted in accordance with the procedural obligation such as notification and attempt at dispute resolution. So in this instance, adherence of the environmental protection is probably crucial if the treaty's goal includes the preservation of ecosystem and the sustainable joint use of shared river. So if Botuna infractions are documented, so they may qualify as a material breach. So according to the Article 60 sub 3 sub B, so defines such a breach as a violation of a provision essential to the accomplishment of the treaty's object or purpose. So in this case, the alleged breach involves State Botuna, which is repeated the failure to uphold the environmental safeguard in managing the dam project. So B is a good faith and procedural obligation. So even in the events of a material breach, so State Aramika is required to fulfill its responsibility in a good faith and adhere to establish procedures prior to suspension. So in the case of in Hungary v. Slovakia, which is under the Gabčíkovo Nagy Project 1997, so the ICJ rules that it was illegitimate that for Hungary to unilaterally suspend and then withdraw from a comparable dam accord. So even In the face of legitimate environmental concern, parties must consult and espouse a peaceful means before invoking treaty suspension. So, Aramica's suspension might be premature or procedural flaws if it didn't try to resolve the conflict by a formal notification, negotiation, or in other meaning. So next is proportionality and scope. So state Aramika response must be proportionate. So Article 60 allows for partial or full suspension, but not more than the necessary to address the breach. So if Botuna's violations are limited to the certain safeguard protocols, so a complete suspension of the entire treaties may be excessive. So in conclusion, state Aramika locus standi is to meet under the VCLT requirements in order to lawfully suspend the treaties. So there are three recommendations that can do. First one is seek arbitrations or joint facts. Number two is prevent unnecessary or premature suspension. And the last one is implement the partial measure or proportional suspension. So in conclusion, State Aramika suspension of the treaty may be legally justified under Article 60 sub 1 of VCLT if State Botuna breach of environmental safeguard constitute a material breach. But however, the suspension is only valid if Aramika also complies with the procedural requirement such as notification and a good faith engagement. So as emphasized in Hungary v. Slovakia 1997. So failure to follow this step could also render the suspension unlawful, which is despite the underlying breach. So thus, Aramika action is conditionally lawful, which is depends on both seriousness of the breach and the adherence of the VCLT procedure. So moving on to the issue 2, which State Botuna defense under the VCLT. So from a journal article, which is Karen's Bill Casey perspective, where due to this condition, some individuals such as Lord Panic have suggested that UK may apply Article 62 of VCLT of 23 May 1969 on the law of treaties in a letter to the Times that date on the March 15, 2019. So can Botunas defend rebus sustentibus under Article 62 of VCLT? So Botuna used the standard rebus sustentibus argument to claim that the climate change has rendered the environmental protection, which is absolute. So Botuna must demonstrate the following order for this to be successful under Article 62, which is the climate change were unanticipated, the original conditions served as an essential basic for its actions, and this change have fundamentally altered the duties of the treaty itself. So the defense of Botuna is unlikely to succeed unless if it can demonstrate the apparent that unusual change for the impact of the dam operation. So under Article 62 sub 1A and 63 sub 2B of the VCLT that stated that is a fundamental unanticipated change significantly that changed the requirement based on the circumstances for agreement to the treaty. So the treaty may be suspended or terminated. So even if Botuna owns inability to adapt the environmental protection was the sources of the non-compliance. So Botuna argues that the current environmental regulations are no longer relevant due to the climate change. But however, in the ICJ, which is held in the Fisheries jurisdiction, cases under UK's and Iceland 1973, that a fundamental change must be unexpected and drastically alter duties. So next, according to the facts, so State Botuna may invoke the defense under Article 62 sub 1 to permit the suspension of the treaty in the event that there is a significant unanticipated violations of the circumstances that are crucial to the original intent of the treaty for both states. So State Botuna may contend that because of the environmental protection are real and weren't anticipated. So when the treaties was signed and climate change has had a fundamental impact on that circumstances. So next, the ICJ dismissed the Hungary use of environmental evaluation as a justification for halting treaty performance in the case of Hungary and Slovakia. So therefore, Botuna application of Article 62 is not persuasive until a fresh information reveals significantly unanticipated and change in the environmentals that make the treaty operations ineffective. So the recommendation that can do is create a mechanism for joint environmental review. The second is use a peaceful method instead than the taking the unilateral action. So the third one is include climate change provision in upcoming agreement. So lastly is in conclusion. So in the event that Botuna conduct represent a material breach and Aramika complies with the necessary procedure, so state Aramika suspension may be justified under Article 60 BCLT, but taking unilateral action without negotiation in a good faith will run the danger of breaking the law. So according to the ICJ, precedents where state Botuna defense under Article 62 rebus 610 are insufficient because the environmental change that are being cited are neither unexpected or not drastically altering. So moving on to the issue 3, so can environmental obligation involve into the just Congress norm, which is overriding the treaty provision? So Article 53 stated that a treaty is void if at the time of its conclusion, it's conflict with the peremptory norms of general international law. So from a journal article's Ejora Ramat perspective, where in contrast to the standard positivism reads down to the state practice, just Congress norm incorporates more rules that pertaining to morality or a natural law. So under Article 64, which is provide if a new peremptory norms of general international law emerge, so any existing treaty which is in conflict with the norms become voided and terminated. But from the journal's article Subtai Rosini perspective, where however Article 64 of VCLT addressed the possibility of just Congress that rules the involving. It does this by providing for the terminations of the treaty that become voided and due to the conflict with the rules of jus congress that emerged after the treaty's conclusion, but sometimes known as a jus congress supervenus or jus congress emerge. Unlike Article 53, Article 64 operates the proactively, which is terminate treaty obligation from the moment the conflicting jus congress norm are universally recognized. So A is present status of environmental obligation under Article 53. So according to Article 53, a state cannot nullify a treaty retroactively unless it can demonstrate that environmental right like access to water has already achieved just Congress status at the time that the pact was signed. So B is emerging potentials under Article 64. So Article 64 may be used to nullify all or a portions of an existing treaty that's conflict with a new peremptory rules that protect the access to the clean water or the environmental right. And C is a conflict assessment and a procedural implications. So to rely on the either Article 53 or 64, which is the presence or establishment of a just Congress environmental law must be applied approved. So second is the clause in the treaty must be in conflict with the norms, not merely incompatible or less aspirational. And lastly, in order to invoke this article, a state must give a legal support that either through an adversary opinion or intentionally adjudication. So there are three recommendations that can do. So the first one is encourage the developments of norms. So the second one is include the environmental safeguard in the treaty law. So in order to ensure the future-proof responsibility and anticipated, so their potential peremptory status. So future treaties should incorporate non-degradable environmental clause. And the third one is create a trigger mechanism in the treaties. So in conclusion, so a strong instrument for preserving the integrity of peremptory norms in treaty law are provided by Article 53 and 64 of VCLT. But however, because of the standard like just Congress norm are not formally recognized, so their use in the context of environmental commitment is still restricted. So the norm must have existed at the time that the treaty was signed as required by Article 53, which is challenged to demonstrate in the majority of environmental situations. So Article 64 holds a greater promise as it provides a mechanism to nullify the existing incompatible treaty and anticipated the emerge of the future peremptory norms. So to guarantee the treaty law continue to be responsive to this fundamental imperative, so Article 64 provides a legal route. So here is my bibliography under primary sources and secondary sources, and the secondary sources on the journal article. So that's all for me. Thank you.